Welcome back to another episode of Spilling Secrets, a podcast on all things related to trade secret and non-compete law. In today's episode, we will be talking about the decision recently issued by a federal judge in Pennsylvania, in which the judge declined to enjoin the FTC's proposed non-compete ban, coming out the exact opposite of a federal judge in Texas. And we will be discussing where this leaves employers given the two opposing rulings in Texas and Pennsylvania. My name is Pete Steinmeier. I am the managing shareholder of Epstein Becker Green's Chicago office, and I am co-chair of EBG's Trade Secrets and Non-Compete sub-practice. Today, I am joined by one of the original Spilling Secrets podcasters, Millie Warner, who is senior counsel in EBG's New York office. Millie, it's always great to do an episode of Spilling Secrets with you.
It's great to be here. Thanks, Pete.
Millie and I are delighted to be joined today by our partner and friend, Paul DeCamp, who served as the head of the Department of Labor's Wage and Hour Division, and who, when he is not performing with his band, is co-chair of EBG's National Wage and Hour Practice and a leading appellate lawyer. Paul, we are thrilled to have you on the show again. We're still hoping that one of these times you'll pull out the bass guitar and play a few riffs for us.
Maybe next time, Pete.
We'll hold you to that. Before we get going today, let me state that we are recording this on the morning of July 26th. We recorded our last episode in which we discussed the Texas case on July 15. When we recorded that episode, I said at the time, who knows what's going to happen between today's date and the date we actually release the podcast. And so I'm going to make the same disclaimer again today. Needless to say, these are very interesting times for us non-compete nerds. But again, we are recording on July 26th. So, Millie, could you start us off by telling us about the Pennsylvania case and the ruling there?
Sure, Pete. So on July 23rd, the United States District Court for the Eastern District of Pennsylvania issued an order in the case ATS Tree Services, LLC versus the FTC, denying the plaintiff ATS's motion for a preliminary injunction to enjoin the FTC's non-compete ban. So unlike in the Ryan case, which is pending in Texas, where the plaintiffs include the U.S. Chamber of Commerce, which represents companies employing hundreds of thousands, if not millions of employees, and Ryan LLC, which employs thousands of people nationwide, ATS is a small local tree care company employing only 12 people, which apparently requires its 12 tree maintenance workers to enter into non-compete agreements restricting their ability to work for competitors within a specific geographic area for a year after the end of their employment with ATS. So ATS had filed a motion for a preliminary injunction to enjoin the FTC's non-compete ban. And in a direct contrast to the ruling by the Ryan court in Texas, the ATS court denied ATS's motion. Specifically, the ATS court found that ATS had failed to establish irreparable harm if the rule goes into effect. And even though that was alone sufficient to deny the motion for a preliminary injunction, the court also went on to find that ATS was not likely to succeed on the merits. And specifically, in contrast to the Ryan court, that the FTC did have the statutory authority to enact the ban. And the court did not analyze the issue of whether the rule was arbitrary and capricious because for some reason, the ATS, the plaintiff, had not raised that in its motion for a preliminary injunction.
So, Millie, I know we've got the Texas case that's ongoing. We have the Pennsylvania case. Are there any other active legal challenges to the FTC's proposed non-compete ban?
Yes, there is one other challenge. There is a case that was filed a little bit later than the ATS and Ryan cases in the Middle District of Florida before Judge Corrigan, Properties of the Villages, Inc., the FTC.
Okay, so if we go back to the Texas case, we know that the court issued a preliminary injunction enjoining the rule as to the parties in that case and only the parties in that case. What lies ahead in the Texas case?
The court in the Texas case has indicated that it intends to issue its merits ruling on or before August 30th of this year.
So what's that going to mean as a practical matter?
It means that we're going to have a few days before the FTC ban is scheduled to go into effect, we're going to know whether the FTC or the plaintiff will succeed on the merits and the scope also of any injunction. The Texas court previously had limited the scope of the injunction to simply the named plaintiffs in the case, as it found that the plaintiffs hadn't fully briefed whether a nationwide injunction was merited in the case. It had invited briefing specifically on that issue. So on or before August 30th, when we get the ruling in the Texas case, number one, we'll know if the rule will in fact go into effect. And if it does not, the court holds that the rule cannot go into effect, we'll know whether the scope of the injunction will indeed be nationwide or if it will remain limited just to the named plaintiffs.
So, Paul, I mean, looking at both the current status quo, where we've just gotten this ruling in Pennsylvania, that was the opposite of the ruling in Texas, and then looking ahead to August 30 in the Texas case, where do things stand procedurally and where might things stand? And I know we're somewhat speculating because we don't know exactly what's going to happen, but people are all asking these questions and thinking about these things. Where might things stand as of August 30 and where do things stand as of the moment?
As of the moment, the Texas case is a little bit ahead of the Pennsylvania case because they issued the ruling first on the preliminary injunction. We have a date by which the Texas court has indicated it's going to rule, as Millie has already discussed. If the Texas court adheres to its initial view on the merits of the rule, then I think that we're likely to see the Texas court issue a final decision in late August vacating the rule. There is some ambiguity as to what the potential scope of the vacature might be. There are theoretical debates among some of the Supreme Court justices about exactly how far a vacature order should go in these circumstances. Should it be as to everyone? Should it be as to a limited group of parties, much like when we're talking about injunctive relief? But I think that the traditional way that a district court deals with something like this, when it concludes that a rule is invalid, when the rule has been challenged straight up under the Administrative Procedure Act, is to vacate the rule. And that would mean that the rule is invalid at that point. At the same time, we have the Pennsylvania ruling where the court is saying that, at least for purposes of the preliminary injunction, the initial assessment of the likelihood of success on the merits, the judge in Pennsylvania feels that the rule is valid. And so I think at that point, it becomes a race to the appellate courts. And we could see in the meantime, the FTC could appeal to the Fifth Circuit challenging the injunction. It may just wait for the ultimate ruling on the merits on summary judgment in August. We could see efforts to try to consolidate some of these cases or transfer or do something to get them coordinated so that we don't have potentially different rulings coming out of different circuits, but that may be inevitable. The Texas case would go to the Fifth Circuit. The case in Pennsylvania would go to the Third Circuit unless something changes. And those circuits could potentially disagree as well. And then we could be off to the Supreme Court.
Interesting times we live in. One of the reasons why I find this area of the law so interesting is that the usual political divides don't necessarily line up the way that people would expect them to. I mean, here, yes, the judge in the Texas case was appointed by President Trump, and the judge in the Pennsylvania case was appointed by President Biden. But things are not so simple politically when it comes to non-competes. We've pointed this out before in comments to the FTC that EBG prepared on behalf of the Illinois Chamber of Commerce and the Greater Boston Chambers of Commerce, and we've written about this before. It's interesting that some of the reddest of the red states, namely North Dakota and Oklahoma, legislatively banned non-competes, along with some of the blue, California and Minnesota. And yet, some of the bluest of the blue, Illinois, Massachusetts, and Oregon, and Washington, have all recently outright rejected outright non-compete bans. So you've got the bluest of the blue coming together with the reddest of the red on non-compete bans, and yet you've got the bluest of the blue also rejecting non-compete bans. And the governor of New York also just vetoed a proposed statewide non-compete ban in New York. So it's kind of an interesting area of the law, and political beliefs don't necessarily accurately dictate how somebody's going to come out when it comes to non-competes. Paul, do we have any indications yet as to how the current presidential candidates view non-competes? You've got Vice President Kamala Harris former President Donald Trump and then vice presidential nominee J.D. Vance. Do we know anything about how they feel about non-competes?
I don't think we've seen anything specific from the campaigns or earlier statements from any of those individuals regarding their position specifically on non-competes. It is possible that's something that will come up in the course of the campaign, perhaps in a debate or in any kind of platforms or position statements that the campaigns issue. But so far, I'm not aware of any of those campaigns having taken a position on this specific rule. I think if we were playing the odds, we would anticipate that Vice President Harris would be generally supportive of the rule, though we don't know that to be the case. And I think that we would anticipate that the opposite would be true for the other ticket. But again, until we see specific statements, we can't really know.
Paul, in that same vein, do we know what impact the upcoming presidential election could have on the pending litigations, including any appeals?
That's an interesting one because the FTC has 5 commissioners appointed to 7-year staggered terms. The current configuration of the commission is 3 Democrat appointees and 2 Republican appointees. The next term that expires is a Democrat seat that expires in September of this year. So it's possible that we could see, depending on how the election goes, a flip in the configuration of the FTC. Now, the FTC Act allows commissioners whose terms have expired to remain in place until their successor is appointed. And so there may be some lag in terms of when the composition would flip, if it does flip, which again, that depends entirely on the election. But there could be a differently configured FTC come maybe January or shortly thereafter. In addition, with respect to the conduct of the litigation, although the FTC has independent litigating authority to go ahead and proceed in court on behalf of itself when prosecuting enforcement matters, it's a different story when someone challenges the validity of an FTC regulation. In that instance, the Department of Justice handles the representation. And when the FTC appears in the Supreme Court, the Solicitor General is counsel of record. And so what that means is that if there is a change of administration or a change of party following the November elections, there would be a new round of political appointees in the Department of Justice, including in the Solicitor General's office. And that, in turn, would give the Department of Justice the ability to determine which, if any, cases to appeal or not to appeal, or to abandon appeals that have already been taken, and what positions to take in the Supreme Court. And so the election could be impactful, at least once we get into next year.
It's going to be interesting to see. Now, both of you have come out publicly as stating that you do not expect the FTC's non-compete ban to survive in the courts. So I'm going to put you two both on the spot, July 26, 2024. Are you still holding firm to that belief?
I'm holding firm, Pete.
Okay.
Same here. I think that there's been enough in terms of how the courts have dealt with agency authority, the major questions doctrine, the Loper-Bright ruling, eliminating Chevron deference, and just courts willing to take a much closer look at whether agencies really have the authority that they claim. I think that this rule, at the end of the day, does not survive judicial scrutiny.
Okay. I'm with you guys on that. So we are unanimous in our prediction, but it is only July 26, 2024. So we will soon find out. Millie, in addition to being asked if I'm still so confident in my public predictions that the FTC's non-compete ban is not going to survive, the other question I have been particularly getting at since the Pennsylvania decision came down this week is whether there are any steps employers should be taking now, just in case the FTC's non-compete ban, in fact, goes into effect on September 4, 2024.
So there are definitely a few things that employers can start thinking about now, just so that they are prepared in case the rule does go into effect. One is to start identifying the so-called senior executives, as defined in the FTC's rule, who have existing non-competes to which the ban will not apply, even if it does go into effect. Another thing is employers might consider joining the U.S. Chamber of Commerce or one of the other intervenor organizations in the Ryan case, if they're not already a member. to benefit from any rulings that will apply to their members by virtue of associational standing, given that the Ryan Court has signaled that it intends to consider associational standing of the U.S. Chamber of Commerce and the other intervenor organizations' members in its merits opinion. Employers also might want to begin to prepare the notices that will need to be issued to employees with non-competes that are no longer enforceable, as well as the mailing list that they will need to actually send those notices out. If the FTC's ban goes into effect, those notices will be due on September 4th, which is only a few days after the merits disposition is expected in the Ryan case. So that's why employers may want to do some of the legwork now to put themselves in a position to issue those notices on short notice if they do need to. That being said, there is no private cause of action under the FTC's non-compete ban, although maybe under some of the state's mini FTC acts. And the FTC can only obtain a cease and desist order from an administrative law judge if an employer fails to comply with the notice provisions. So the risk of waiting until the Ryan Court's August 30th ruling to begin the process and maybe being a little bit late in issuing the notice is probably relatively minimal. And finally, just more generally, employers might want to start evaluating alternatives to non-competes, such as garden leave provisions or enhanced confidentiality provisions, non-solicits, maybe doing trade secret audits, and generally just trade secret training programs.
I agree with all of that. And I think sort of our bottom line is no need to panic right now, no need to rush out notices right now. After all, how can you, as a practical matter, pull those back if you send them out now and you give notice to your employees that you have a non-compete that's not enforceable, and then lo and behold, it later becomes enforceable? It just seems to me you're going to have a real problem on your hands. Any final thoughts, either of you, Paul or Millie?
Just stay tuned for further developments, including action in the appellate courts.
Millie, how about you?
There are just so many developments right now, and we also have the Middle District of Florida case in addition to the appeals that will inevitably come in the Texas and Pennsylvania litigations. So this is an area that everyone needs to keep watching.
I certainly agree with that. Thank you both for joining today.
Thank you, Pete.
Thanks, Pete.
And as always, a special thank you to our listeners. If you would like to subscribe to Spilling Secrets, please go to ebglaw.com/subscribe and click the box for Trade Secrets and Non-Competes Spilling Secrets podcast series. Thanks again for joining. Until our next episode, this is Pete Steinmeier signing off on behalf of the Spilling Secrets team.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.